the July webinar from the Phia Group called The Underlying Regulatory Landscape. Don't get lost in the new normal. New normal, I love that word. I don't know what it means. I guess if it's new normal, then it's still normal. I don't know, or it's not normal. I don't know. I'm confused. But folks, the reason why I'm a little off today is I'm in my basement. I'm not at our beautiful new offices. I'm stuck in the basement because, well, I got 4 kids. And today is just one of those days where I had to work from home. I'm assuming there are many of you out there. Feel free to send me something in the chat if you're in the same boat as me. But I've already had about 3 close calls of near-death experiences this morning with my kids throwing a couple things at me. Once took a squirt gun and squirted me right in the back while I was on a conference call. So it's all good here. Can't complain. All right, Matt, let's get to the next slide. Don't forget, folks, to stay ahead of the COVID-19. If you don't know what it is by now, I wish I was you. Contact us at pgcreferral@fiagroup.com with any questions related to it. We've done over 1,000 projects related to COVID for a bunch of people in the self-insured industry. We're still doing them because this thing still hasn't gone away. Matt, next slide. Today's overview, folks, just so you all know, we're going to talk about the PGC most frequently asked questions. I can't believe, if you've been to this many times, you probably know who's going to be leading that, as well as the next section, the political update. Brady Bizzaro, I'm assuming, is going to be talking about the election 2020 preview and how, based on all the polls, Trump is going to lose in every single state. In addition, we're going to talk about part 2 of the stimulus. Then we're going to talk about the new normal and what you need to do about this new normality we have. Then the regulatory updates you need to know about, testing, and also pharmacy copay assistance, how that relates to obviously the COVID testing. And last but not least, there's a lot of litigation to discuss. There's an update on the California and Texas contraceptive mandate rules, hospital pricing. We all talk about hospital pricing all the time. We're going to talk about some of the new rules, new litigation that we're seeing relating to quality and transparency. Okay, today's speakers, Matt. It's me, that great looking guy on the left. That's me. I'm better looking now than I was even in that photo. And as always, join us. He had some technical difficulties. I think he lost internet at his home, or his house was flooded out, hurricane, something happened. Not really sure, but he is with us. Say hello to Ron E. Peck. Say hello, Ron.
Hello, Ron? I don't recognize myself. I do not look like that anymore.
How are you on this webinar today? What happened?
Adam, I found a couple sticks. I rubbed them together and I managed to get a signal. So I'm with you.
Clearly, I'm not paying you enough money. You got evicted from your home. Something happened. I'm not sure what it is, but we're happy that you were able to join us from that park bench you're sitting on. Great. In addition, as always, the lovely Jennifer M. McCormick. Say hello, Jen.
Hello.
Oh, hello. Jen is our Senior Vice President of Consulting, and I'm assuming you're going to be talking about PGC's most frequently asked questions. Is that correct?
That's correct.
Well, this isn't my first time doing this. You know what, Ron? I'd like to know, can we actually, for the next webinar next month, actually know the number of webinars we've done, the monthly ones, not the special edition ones, just monthly webinars? It'd be great to know.
I think that's a great idea, Adam. Maybe next time we should shake it up a little, I could do the intro, you could do the FAQs, Jen could do politics.
Not gonna happen. Anyways, last and certainly definitely least, Brady C. Bizzaro, our Director of Legal of La Cara. It's our Spanish network, the Legal Compliance and Regulatory Affairs. Say hello, Brady.
Hello, Brady.
Are you wearing the Phia fleece today, Brady? It's all people want to know.
I'm not. It's way too hot for that today.
Way too hot to wear the Phia fleece. Are you wearing the Phia t-shirt that I gave you 3 years ago that still has stains on it?
I actually do have that on, believe it or not.
See? He is wearing the Phia t-shirt. Folks, you want to be one of those people that we shout out because you get a Phia t-shirt for that. So remember, to the thousands of you that are dialed in, thank you so much for doing it. Let's go to the next slide, Matt. Feel free to follow us on LinkedIn. There are thousands of you that do it already. As you can see, we have stories every single day. Everything's free of charge. We want this industry to be as knowledgeable as it possibly can because it's going to benefit all of us in the long run. In addition, we've been picking up a lot of podcasts lately. We have a lot of them scheduled. Feel free to listen to them on our website or download it on Apple Podcasts or on Google Podcasts as well. Next slide, Matt. Folks, I think it's really important that we bring this up to you today, and the reason why, it's free. Many of our TPA clients that we work with, many of our brokerage firms, you've obviously seen a massive decrease in the number of claims that are being processed. Claim volumes are down, which is good news for your employer groups because costs are way down, right? No question about that. I think I saw something recently, United Healthcare's profit margins up by 50%, obviously tied to the whole COVID piece, the fact that people can't go and schedule surgeries. I would recommend, if possible, in order to educate your staff, if you have any new staff, the ins and outs of self-funding is Chapter 1, talking about the laws that apply to self-funding plans, preemption, etc., appeals, Chapter 2, and then talking about what PACE is, how we sell it, how we discuss it, the value proposition related to it is Chapter 3. There's no cost, just sign up. I recommend it to all of you to educate yourselves and your teams internally. Next slide, please, Matt. This is something I'm very excited about. We have sent this subrogation value report out to every one of our full data scrub subrogation clients. Over 190 of you have received it, I believe, this past week from our customer success team. And it's awesome. This is a sample of what it looks like. It talks about just your activity, how many lives you have, how many cases we have activated, how much they're worth, what we expect in the recoveries. Then we compare what your results are compared to the industry average, as well as your results as it compares to our entire book of business. Everything from how long a case takes from the date of accident to the date we actually settle it, to how the recovery rates are based on the circuit or state law that your plans are in. And this exact same report is created for you on a quarterly basis or whenever you want. But in addition, we can have this made for your groups, all of them, individual groups. If you want to have a sample shown to a prospect, you can have access to that. If you want to give it to a group prior to a renewal meeting, you can have access to that too. If you're interested in this, please feel free to contact the client success team. You're going to have the names of those people on the next slide, Matt. This is the people on the client success team. Rebecca McGuire-Dye, Michael Vaz, Krista Bellinger. These people, basically their job, they lose their jobs if you're not happy. Put it that way. So if you want me to make sure they don't get fired, just tell them everything's great. I'm just kidding. Folks, seriously, anything Phia might be doing wrong, any issues, data issues, revenue issues, accounting issues, not happy with the service, whatever it might be, if you want access to reports, these are the contact people for you. In addition, go back to the other slide, Matt, really fast. If you don't mind, go back one. On the Subro value reports, we are now creating this and close to being implemented for all of our balanced bill defense clients, all of our unwrapped clients, all of our PACE clients will have this. Every line of business that Phia has, we will be sharing value reports with all of you. A couple questions are coming in via chat. If you want to find out who the information was sent to, go to the next slide, bud. Email Rebecca. So Matt, if you wouldn't mind just sending Rebecca, Mike, and Krista's information to everyone that is dialed in today, that'd be great. They're the ones who sent them out to all of our clients, and they can tell you who received it and also forward one to you. Now, as always, we do a special shout out. This guy, go ahead, Hobson Carroll, he's the man. Let me tell you this. There isn't a month that goes by where we don't see, what, Ron, 20 texts from him, at least? He just loves to tell us stuff. He loves to tell us how great he is, loves to basically question everything we say. To be honest, I love Hobson for one reason. He makes me work harder, and he makes me better at what I do. So Hobson, he's at MedRisk Actuarial Services. He's a great guy. You'll be getting all of the Phia swag. I think, Matt, it's everything from T-shirts to hats, gloves, jackets, underwear. If we have it, we're going to send it over to you along with the Phia backpack. Hobson told us he was traveling by train to London with a London broker. Of course, you know, an American broker is not just good enough for Hobson. He's so good, he goes to London brokers to visit a client. And he rolled past a particular picturesque meadow with a herd of cows that his companion commented, "Oh, look at that bunch of black and white cows out there. Quite a lot of them, huh?" I took a quick glance and replied, "Well, they do appear to be black and white on the side we can see." Does anybody else on the panel think this is funny? Ron?
I think the delivery. It was all in the delivery, Adam.
It wasn't a good delivery?
No, it was a great delivery. I'm laughing.
I mean, I don't know. I don't get it. Maybe Hobson can tell us how this is supposed to be funny. But that's okay. Anyways, Hobson, thank you for literally listening every month. We know you're out there. If he doesn't send us a message, then we know he doesn't work anymore, I guess. He might have retired. All right. Next slide. We're almost done, folks. Next slide. Want to tell everyone, yeah, that's not the office that we sent you guys last time, which is our new headquarters in Canton, Massachusetts, which is beautiful. This is going to be our new Louisville location, which is where our Louisville office is moving to this state-of-the-art building in September. Up to 60 people will be housed there. We're excited about our growth. As you all may know, Louisville is based like a subrogation hub. It's where all the top people in the subrogation world basically live. So we're excited about our expansion to Louisville, and it would not have happened if it wasn't for all of you. Anyways, oh, Hobson, you are here. Look at that. He wrote, this is the greatest slide ever. That's great. We're happy you dialed in. And that's the first time he's ever said something positive about us. Next slide. No, but just kidding, Hobson. You're great. And I'm going to turn it over to Jen McCormick. Say, Jen, take it on.
All right, thank you. The most anticipated part of this webinar are FAQs. So we couldn't kick this off without talking a tiny bit about some of the questions that we are getting that relate to COVID. So as now people are starting or trying to go back to the workforce, we're trying to figure out the best way that we can adjust after all of the different changes and modifications that we had to make. So one of the questions that we have been getting is, how is it that I can deal with all of these rehires that we're hoping to make and bring everyone back on that previously had been terminated or laid off? And how is that going to have any impact when it comes to break-in service rules under the employer mandate and the ACA requirements? So there's a couple of things to consider. So the first thing to consider when you're bringing people back onto the workforce is looking at the particular employee. So you're going to look at this on a case-by-case basis to determine whether the specific employee previously had been enrolled in that plan prior to termination. So if they had been enrolled prior to the termination, then they should be offered coverage generally by the first of the following month or as soon as possible. So note, this is the rule that would apply for anyone who is terminated, not necessarily for those who were furloughed or laid off. The second consideration here is taking a look at that particular employee's Affordable Care Act status as full-time. And that's going to dictate whether or not they return and how you're going to actually calculate their hours. One of our favorite things to talk about is the look-back method when you're calculating employees. So if you're looking at or utilizing the look-back method under the Affordable Care Act, that means there's that 13-week window that you need to look at, or 26 weeks if you're an educational institution. And if someone is returning within that period of time, then they must be treated as that ongoing employee. So that means they're going to act as if there never was a break in service and being brought back on right away. Other things to consider quickly before we go to the next FAQ is talking about how you're treating furloughed employees. And when you're examining those, you need to take a look to see whether that furlough that was being offered was either paid or unpaid, because there's different consequences that would apply based on someone being on furlough for an unpaid circumstances. The other thing to consider is COBRA. And we've talked about this in the past, that there are those extensions now that the COVID regulations have brought to us that allow us extra time to select COBRA, extra time to make payments. So you're going to have to pay extra attention to those individuals who have been termed, who are on COBRA, and how it is that you should or should be keeping them as beneficiaries. Let's go on to the next FAQ. All right, so the next FAQ here is talking about retirement benefit plans and how we can offer those to, whether they should be offered to executives only. So there are some nuances to consider within the regs about what happens for retirees and how they can be treated. So the question was posed to us a few times about whether or not that exception within regulations could be used to the benefit for a retiree plan. The long answer here in reading these actual regulations is that essentially there could be an exception. However, that exception to discrimination only apply if you would be able to use whatever benefits are being offered for retirees for all retirees. So that means that you could not apply a plan for executive only and assume that because of the executive only plan was being a retirement plan that you're going to get away with having to escape the discrimination or the 105 requirement. So essentially, if you want to offer a retirement plan, it needs to be offered to all retirees and not limited to executives only if you're hoping to avoid any 105H discrimination concerns. And I'll turn it over to you, Bernie, to talk about the political update.
Thanks, Jen. And I would contest that the PSC FAQs are the most exciting part of the webinar. I think this is, but especially now because, look, folks, we have an election coming up. Who would have believed it? But on the next slide, you'll see exactly what we're talking about and just what the stakes are in the coming fall. So if we can get the next slide, Matt. You'll see that, look, we've got a raging pandemic, we have an economic recession, and we have an election coming up. And there's serious concerns about how this might play out, right? With states going back into lockdown, we've already seen a number of states have all kinds of glitches in their elections for primary elections and statewide elections. There's really no telling how this could play out in the fall. But because we're seeing a upswing in COVID cases in swing states, this could be interesting in the fall. So states like Florida, Michigan, Wisconsin, Pennsylvania, North Carolina, Arizona, all states the president has to win again in order to win in the fall, are all seeing spikes in COVID-19 cases, and it's really impacting his polls. And so this time around, what we're seeing is that Vice President Biden is leading in most of the polls. That happened 4 years ago, but this time it does seem like the president is behind. He's making some changes, and we'll see if those impact his poll numbers. But why we should be concerned as an industry is because there are 5 issues that this election will shape that really will have an impact on healthcare. One, of course, being the COVID-19 response. Depending on who wins in the fall, we'll see the government's approach to tackling this pandemic change. We've already seen, in terms of testing and vaccine development, there's movement happening, but I think it's fair to say that if Biden wins in the fall, you'll see a lot more government involvement on that front. You'll probably see an expansion of the Affordable Care Act and the offering of something that's being called the stopgap public option insurance, where anyone who's been impacted by COVID-19 under a Biden plan would be offered either a COBRA premium subsidy or a version of a public option. This is a plan that's been floating around out there for a while now, but it will probably only happen if Vice President Biden wins. And we'll have to see how that plays out in the fall. But if President Trump wins re-election in the fall, I think it's likely to say that the Affordable Care Act itself, its fate will probably be sealed. If the Supreme Court doesn't strike it down, you'll see that the Republicans in the Senate, along with the president, will continue chipping away at the ACA, and we'll have to keep, covering how that impacts the impact on employers and your plan. You'll also see prescription drug pricing reform. I think that you'll see, if the president wins re-election, you'll see that stall out because of COVID-19, there's been very little progress on prescription drug pricing reform. And if the president wins re-election again, I think you'll see that stall continue because Republicans in the Senate are not interested in taking up a bill, whereas the Democrats are. I think the same thing applies to Medicaid expansion. If President Trump wins re-election, you'll probably see that Medicaid will not expand in the remaining 14 states where it hasn't been expanded. And if Vice President Biden wins, you'll see the opposite happen. The biggest game changer I'm waiting to see is supposed to happen later this month when Vice President Biden will pick a running mate. And there's 2 people really on the screen here who are in contention, one of whom, obviously, as we know, has a strong inclination toward Medicare for all. So if Vice President Biden picks someone like Warren for his running mate, that could have a really big impact on how his healthcare plan looks in the fall. So I expect he'll make this decision by August 1st, certainly by the middle of August, because that's when the convention for the Democrats will take place. So we'll know in the coming weeks who he decides to pick. Next slide, Matt. Another big development we wanted to cover here is that the House of Representatives at the end of June passed a bill which expanded the ACA. This was largely ceremonial, I would say. It's done in response to what's happening at the Supreme Court now with the Trump administration asking the court to strike down the ACA. The Biden camp and the House Democrats are calling foul here, saying that it's a bad time to do this in the middle of the pandemic. So they passed a bill which would effectively restore all the cuts that were made to the ACA by the Trump administration. This probably has no chance in the Senate, but it's important because, like I mentioned before in the previous slide, it does sort of play the hand of what the Democrats are looking to do in the fall. they do intend, if they win, to restore all the parts of the ACA that were removed. So this is everything from the individual mandate to the contraceptive mandate to getting rid of the short-term plans that came out last year from the Trump administration. They would revoke guidance on these Section 1332 waivers. Those are waivers that allowed states to ignore certain parts of the ACA. This bill also would allow federal health officials to negotiate the price of drugs under Medicare, which was something that the administration supported, but has now they turned against it. This bill would save a ton of money over 10 years, mostly through increases in taxes on those high-priced Cadillac plans. But we'll see what happens with this bill. I think it's interesting that they passed this bill. It's ceremonial, and it does sort of tip the hand of the Democrats' plan for the fall. Let's go to the next slide, Matt. The last big thing I want to talk about in the update here is about the next round of stimulus. I think we're on number 5 at this point. We've covered the CARES Act. We covered the HEROES Act last webinar, which was an act that was passed by Democrats in the House actually 2 months ago now, and has been sitting there ever since. And there's a lot of pressure on the Senate to make something happen here with the stimulus because the stakes couldn't be any higher. You've got cases spiking, things are shutting down again, the economy's in trouble, and of course, the Senate goes on vacation again in a couple of weeks. So they've got to get something done really in the next 2 to 3 weeks. And what we've seen so far is that there are 4 areas that are going to be the focus of this new bill, although I think it's fair to say that the parties are pretty far apart so far still. One of those, though, impactful for you guys, for our clients, is liability reform, right? If you open up your workplace, what's the guarantee that your employees don't get sick and sue you? So what we've seen creep out in the details is there would be this 5-year liability shield for businesses, for healthcare providers, universities, and schools. And I expect a few more industries to be added to that category. And effectively, as long as you put in place reasonable measures to protect your employees from COVID-19, you would be shielded from liability. That's something that the Republicans are going to insist on. I've even heard that they're tying that to funding for schools or cities and local governments as well. So it's a big deal for them. Of course, it wouldn't apply to acts of gross negligence. So, for your employees and people who are concerned, there's still some protection there. We also expect there to be another round of stimulus checks to come out. This time, though, the word on the street is that it would only apply to workers making less than $40,000, so a bit less generous in terms of who gets stimulus checks. No word on whether the idea for COBRA subsidies would be preserved. That was contained in the HEROES Act. And remember, that's important because with record numbers of people losing their employment, they're losing their health care coverage as well. And they can't afford COBRA in many cases. So having the government step in and provide a subsidy makes a lot of sense. And there's actually some bipartisan support on that front. And we'll keep watching to see if that makes it into the next round of legislation. And again, time's running out. At the end of July, a lot of these extra benefits that were put in place in the previous bill expire. So they really have to act now. And we'll see how this plays out and what other things creep into the bill moving forward. Next slide. And I'll turn it over to Ron to talk about the new normal.
Thanks, Brady. So speaking of time running out, I won't spend too much time talking about this. Let me first say my attitude regarding the term the new normal. I don't like it. I don't like it because it seems defeatist to me. Saying that, well, this is life as it's going to be for the foreseeable future. I prefer to think of this as sort of a temporary normal. But maybe I'm being overly optimistic. But regardless, the one thing that we know about benefit plans in general is that they are often interpreted in light of normalcy. So what do I mean by that? We talk all the time about hazardous hobby or activity exclusions in a plan document, right? And, you'll say, oh yeah, it may be hazardous to ride a horse in the middle of Boston, but it's perfectly normal in somewhere in Texas, right? Or somewhere else where it's just more commonplace. And so normalcy in an area kind of casts a light, or it's the lens through which you interpret a plan. And so when we talk about the new normal, we're going to have to start interpreting plans through this new lens. An example being, we hear about in the news people going to a COVID party, right? It's what the kids are doing, where somebody's been diagnosed, and so everybody goes and they go to see, hey, can somebody else catch it? Is that a hazardous activity? And if so, if somebody ends up contracting the disease because of that activity, does an exclusion apply? What do you think? What do you think stop loss would say? So just one example. You have
And Ron, to add to that, Ron, when you're looking at when you mentioned stop loss, well, it also depends on what their ability to interpret the terms of the plan is too, right?
Exactly.
So all that's going to tie in regarding what is a hazard activity, what could possibly be excluded. The guidelines. Is it a guideline? Is it a rule? Is it a law that a particular state has passed or even a town has passed? And we've seen that happen even here locally. So very important.
And right. And so, and of course, I'm talking about extreme examples, a COVID party, but what if there's just a public gathering and you go and you don't take precautions, right? You're not wearing a mask. In some states and municipalities, there's a requirement that you wear a mask. Does the illegal acts exclusion come into play? So one, it has to do with the area where you find yourself, the rules and laws that apply. Two, who has the right to interpret the terms of the plan as far as discretion is concerned. So there's a lot that goes into this. It's something we need to pay attention to. And that leads right into the next issue, which is workers' comp, right? We've been talking a lot lately about workers' compensation and how workers' comp may be responsible to pay for some COVID treatment, particularly if it's something that you contract while at the office. But Brady mentioned before responsibilities on the part of an employer to ensure that the workplace is safe. Well, if workers' compensation carriers haven't thought of it yet, they will soon. Of course, they're looking for opportunities to pass the buck, right? And they would look at their insured. Who's their insured? The employer. And they're going to ask the employer, did you take the necessary measures to ensure that you were providing a safe workplace? And if you don't meet certain standards, does that somehow limit or eliminate your coverage under workers' comp? So just like other hazards at the workplace and how those hazards could potentially void a workers' compensation protection, could we start seeing that here as well? So ensuring that the employer is taking the right steps.
Hey, Ron, in that regard, right, when it comes to workers' comp, so we've already adjusted and made changes to our own process and logic routines when we're scrubbing claims data, because now there are new COVID claims that are coming in, which could be attributable to workers' compensation paying those claims and not the self-funded health plan. So that's obviously something that we're doing here. So just something I want everyone to be aware of. We're on the cutting edge when it comes to that, to identify not just your typical trauma claims, but now are there potential COVID claims that should be paid by someone else, such as a workers' comp carrier. That's another whole COB issue that we're seeing. In addition to that, Ron, from the workplace standpoint, and it also ties into healthcare, but really it applies to the self-funded employers. Claims are down, no question. So we're seeing that many of the 10 million plus people that are potentially could lose healthcare coverage because they get laid off or they're furloughed and they don't pick up COBRA. Okay, what happens to those folks? Well, the TPAs and organizations that we're speaking to, most self-funded plans right now are ecstatic as it relates to what they're seeing from a claims exposure standpoint. Claims are way down, right? But what they need to realize though is that maybe most of those claims costs will end up coming back. Maybe not now, but when things do open up and people are able to schedule surgeries. But would we expect 100% of those surgeries that would have happened? Do we expect 100% of those surgeries to ever happen? My guess is no. There are going to be some people that said, you know what, I wanted to have that surgery. It didn't happen. Now maybe they don't just postpone it. They never have it. It also ties into, I know, Ron, you're going to talk about it in a bit. I'm not going to steal your thunder, telemedicine. But most people right now are doing all of their doctor's visits remote, right? Whether it's a video conference or over the phone. Are they going to go back to the office setting once this is all done? Some will, but I would assume that there'll still be some that don't. So there are positives as it relates to claims costs going down. Obviously, claim volume has gone down, but how much of that's going to come back, what percentage of it, I think is still unknown. Ron, turn it back to you and I'll quiet down.
I think, Adam, that, it's interesting because some claims, it's postponement versus cancellation, right? But others, one concern that we have is if some treatments have been postponed, will complications develop so that the claims end up in the future being more excessive because the condition has worsened than if the person had sought treatment now? And as far as telemedicine is concerned, I think that necessity is the mother of all invention. And I think that once people get comfortable with telemedicine and the convenience, even when it's safe to go to the office, why wouldn't you continue to do this? And Adam, you and I are prime examples. We've been using direct primary care, or TPC, which I know is there applied, for years now. And it wasn't because of a pandemic. And I know you, like I, frequently use texting or virtual visits with our doctor.
Ron, just within my own family, Ron, 3 additional members of my family are now doing direct primary care, but it's directly related because of COVID. My kids, they're doing direct primary care now because they couldn't see their pediatrician in person. So,
but when things clear up, when things clear up, do you foresee that they'll continue to take advantage of these tools?
I think, well, at least in my situation, they won't go back to the old way. But again, everyone's different. One thing really quick, Ron, I want to add, Jen, when it comes to telemedicine, I hope you're there. What percentage of our plan documents that we work on allow or encourage telemedicine versus the normal office visit?
Yeah, I would say that historically it was about a third that you saw that had some sort of modification or allowance for telemedicine, whether it was traditional telehealth or through some sort of vendor. And over the past few months, this has been one of the most frequently requested changes to make sure that specifically telehealth is allowed. So I'd say that percentage is continuing to increase. And as we enter renewal season, it'll continue to go up.
And it'll continue to stay on, right? Those that have it now are going to go back to not having it. Understood.
Exactly.
Yeah, no one's letting go of this. Yep.
So, we can go on to the next slide, Matt. We're talking a lot about the changes and sort of the new innovations, and that's great. But at the same time, while many of these changes and innovations are a result of just trying to stay ahead of trend or be as innovative and profitable as possible, others are in response to requirements. So really, it's a two-pronged approach, right? One, you need to know what is a best practice in light of the market, and 2, you need to know what's required by law. So how are we answering these questions, right? Well, 1, we have to keep track of new rules and laws that are coming out. Brady, very gracefully explained some of the rules that have come out, been knocked down, come back, get knocked down. But this is a developing situation. The problem is that unlike a lot of other issues that we deal with, there is very little precedent, right? I know if you look further down on the slide, you'll see there are bullets talking about large dollar claims and stop loss. One of the ways that we always look at claims and decide, is this excessive or not? Is this reasonable or not? Is we compare it to other examples. But in the instance of COVID-19 in this pandemic, there's not a lot of history to draw from. Last webinar, we talked about that story about that gentleman who had the $1.whatever million claim. And of course, it seemed excessive because of the number. But that kind of begs the question, is it actually excessive? Or is everybody going to be billed $1 million? So you need to start looking at other benchmarks or other parameters besides what other providers charge for the same service. And that really, I think, I don't want to call it necessarily reference-based pricing, but sort of the same philosophy where you need to take into consideration other benchmarks besides just past precedent. And then the last thing I'll say with this slide before turning it back over to Jen is you have to pay attention, mind the gap. I know, Adam, it's been a long time since we said mind the gap, but gap reviews are more important now than ever before. Because with everything that's going on, with all the sudden changes, this is a situation where HR professionals thrive. Their employees are scared, they're looking for help, and this is what the HR professional has been training for all their lives. And so they're going to take that handbook and they're going to start offering new benefits, new opportunities, new flexibility for their employees. The issue then becomes, does your plan document keep up with that handbook? If somebody is changing the rules regarding in-office versus working from a satellite location, does the plan document recognize someone working from a satellite as an active employee and therefore eligible to remain on the plan? You better make sure that it does. So again, as these handbooks are being updated in light of sudden changes in the world, the handbook and the plan document must match. And then, of course, you have to coordinate with stop loss as well. And all of this needs to be done before the claim comes in. Speaking of somebody that I always try to coordinate with, Jen, you're up.
All right, thanks, Ron. Okay, so now I like how Ron phrased it, the temporary normal, the optimistic view. I'll take that view too. So there are certain things that we need to be aware of as we're trying to navigate our way through this. So One of the things to be aware of is that the deadline for the public health emergency is to be renewed. So originally this was set to expire in just a couple of weeks, and now it is going to be prolonged by an additional 90 days. I think at the outset, none of us knew that we would still be here at this point. We're anticipating that this would be okay to expire, but now we know that this is necessary to continue this, at least for these additional 90 days at this point, since there are a lot of different resources or regulatory policies and things that are actually attached to this public health emergency designation. One of the things that's listed here is the 20% add-on payment for those providers who are treating those COVID-19 patients. Other things are some Medicaid matching, some telehealth restrictions and the waivers of those. But most importantly here, when it comes to the actual self-funded plans, this must be something to pay attention to, because specifically the amounts that we are allowing for no cost sharing, no deductibles, no copays for this COVID-19 testing is tied to the end date of this public health emergency. So as of right now, as extended, these plans still must continue to cover the testing, the diagnostic testing, without any cost sharing until the end of this emergency. So make sure for any amendments or modifications that had been made that there was not an end date of July 25th, because that would not necessarily be appropriate. Next slide. One of the other things that we need to talk about when we're talking about this testing here is how we can handle this as we're bringing people back to work. So just recently, there were some FAQs that were released that outline some of the things that we need to consider about COVID-19. And one of the hot topics now that people are asking us are what to do and how they can do it when it comes to returning to work. Can they offer this testing? Does this testing have to be covered under the plan? So there's a difference between a return to work program or whatever it is that it is being called return to work testing. And under the regulations at this time, the CARES Act, there is no specific requirement that the plan is covering the return to work testing, because the return to work testing is not necessarily for the diagnostic purposes. And that's where what the regulations are outlining that needs to be covered with the zero cost sharing. So just as a reminder about who and when there needs to be some sort of testing that is covered by the plan, that is a clinical determination that is going to be made by the individual's actual physician. So there are certain conditions and considerations about whether or not there are symptoms, whether or not the individual has actually come into contact with somebody, but those clinical decisions are not for the plan to make as part of the return to work testing, but something that the actual physician is making. So there's no required coverage under the plan for that. The second thing that has been important or that has come up from these FAQs, and they're actually part 43, and those were released on June 23rd, I believe, is about whether or not a plan is going to be required to cover multiple tests. So there were some concerns about whether a plan could put a limit, frequency 1. Once you get your one COVID test, plan's obligation is all set when it comes to the cost sharing requirements. And we know from these FAQs that that is not the case, that an individual can get multiple tests as long as they are diagnostic, which is one of the triggers, covered under the plan without that cost sharing. So there's no limitation right now with respect to the number of diagnostic tests that an individual could be provided. So a doctor could order 5, 6, 7 of them as long as they are appropriate. So in saying that, the other consideration here is making sure that they are medically appropriate, to make sure that they are following whatever medical management requirements are set to be in place so that they are actually appropriate. So those plans cannot impose any sort of pre-certification or prior authorization requirements on those or deny those tests, but they are encouraged, to the extent that they can, refer to those CDC guidelines as they're outlined to make sure that any sort of local or national or regional guidelines are also being followed when it comes to the determination of what diagnostic testing would be appropriate for the individual. So make sure you check your plans to remove any limitations that would be outlined for a coverage for these tests. And I'll turn it over to you, Brady, to talk about some copay assistance.
Great, thanks, Jen. Yeah, another important rule that came out that will impact your plan design and how you sort of administer your plan going forward. We've covered this extensively, the issue of copay assistance programs, as plans are looking for ways to cut back on drug spending, everything from importing drugs from abroad and sending people to Mexico and all kind of craziness. One of the more popular tactics was to implement these so-called copay accumulator programs, which over the past couple of years, there's been conflicting guidance. Our position had been before this rule came out that you were not allowed to exclude patient assistance amounts from a patient's out-of-pocket maximum. Basically, with a copay accumulator program, the health plan prevents the value of a copay coupon from counting toward the beneficiary's deductible or annual max out-of-pocket. And so after the coupon value is exhausted, the member would be on the hook for the entire amount of the deductible. And that was done for a number of reasons, some of which make a lot of sense, because these patient assistance programs oftentimes can steer patients, as we know, to choose a more expensive drug with an attractive coupon attached to it when there's a generic version available that's just as effective. So this was one of the ways the plan could combat that practice. Now, previously, there was existing guidance from CMS that seemed to indicate that you were not allowed to exclude this amount, that you had to apply it toward the patient's out-of-pocket max. And if you did that, the patient would quickly hit their out-of-pocket max and the plan's on the hook. What this proposed rule has done for 2020 is it's giving employers the choice of what they want to do. If they want to include or exclude that patient assistance amount toward the patient's out-of-pocket maximum, they can do that. Originally, the proposed rule was to only permit the exclusion of the assistance amount if there was a brand name drug being taken that had an appropriate generic equivalent. That led to some backlash by employers and insurers, and now it applies in all cases. It gives you the choice as the employer on what you want to do, what's best and what's right for your plan. Although there's two notes here. If you do choose to exclude the manufacturer support from the annual cost sharing limits, then you have to apply your policy in a, quote, uniform, non-discriminatory manner, consistent with existing obligations. That's obvious, right? We always know about the uniform application of these policies. The other thing is, importantly, you've got to be clear and transparent and communicate with your enrollees exactly what you're doing. So tell them that the value of drug manufacturer support will accrue or will not accrue to the annual limitation on cost sharing, depending on what you want to do as a plan. So this is a big deal. It's giving you the employer a choice here. But the rule weirdly lets state laws supersede the federal rule, which you don't normally see. 4 states don't like this rule. I've listed them here and have made laws that prevent you from excluding the patient assistance amount toward the out-of-pocket max. So we'll have to see if other states follow here. But for now, what this means is you can review your plan language, see what you're currently doing with copay assistance. If you have questions, bring them to us. We can help you answer them. Let's go to the next slide. Okay, this one I could spend an hour on. I know Jen could too, because this was an important rule that came out last month, but I want to just highlight an example here. We know that the outbreak period has been extended, right? The emergency declaration has been extended. So this outbreak period lasts until 60 days after the end of the emergency period. This has a ton of impacts on a number of deadlines and dates that are relevant for all of these federal laws that we list here. But I want to just remind everyone listening that you've got to be very careful when you're administering claims and determining eligibility, not just on the issues that Jen mentioned, but for COBRA especially, right? What the rule effectively does is it gives a beneficiary a lot more time in which to elect COBRA. They have 60 days following the end of the outbreak period to elect COBRA if they're eligible. And then they have 45 more days after that date to make their first premium payment. So make sure you're keeping track of the dates here. Don't defer sending out notices. It could really get more confusing for you as an employer when you're trying to find out what should be paid, and what's not eligible. But what you don't want to do is end up paying claims that were not the plan's responsibility, because of all the extra time allowed to beneficiaries, you might be in a position where you have to tell providers and hospitals who are asking about coverage that the person is in a retroactive period, which they could be covered, but they may not be covered eventually. So you have to keep track of the dates, be really careful. If you have questions on the claim, again, reach out to us. We can help you with that. Let's go to the next slide.
All right.
Back to Jen.
Thank you, Brady. I can quickly kind of go through this one. This is just a proposed rule that we wanted to bring up quickly. So hopefully you all remember that there is such thing as a grandfathered plan, and hopefully a few of them still exist out there. So this is a proposed rule that was put into place that would potentially allow some additional flexibility for grandfathered plans. There's two things that this would do. The first thing that this rule would do, if finalized, would allow a grandfathered plan that's considered a high deductible health plan to make certain increases to their fixed cost sharing requirements, like a deductible, to make sure that they can otherwise maintain their status as a high deductible health plan without having to lose their grandfather status. The second proposed change would allow for an alternative as far as how a plan is allowed to make those increases in the cost sharing so they can actually better account for how it is that the cost of healthcare has been rising over time. So we're looking and expecting these comments to be all submitted by the middle of August, and then from there, based on that, we'll see what actually happens. So I know there are not a ton of grandfather plans out there, but this is, I'm sure, welcome news for the few that still exist. All right, next slide, Matt. All right, the other thing that has been important for us to talk about as we're thinking about changes that would have an application for our plans is this IRS guidance. It was IRS Notice 2020-29, and it has allowed some greater flexibility for these cafeteria plans, and this is important. So now there is an opportunity. It is not mandatory. It is optional for those employers who are hoping to make modifications to their cafeteria plan and allow a mid-year election. So this is permitted through the calendar year 2020 for these plans if they have an FSA or a DCAP or a major medical plan. So there's a couple of things that this would allow. This would allow the employer to set an election for you to do this on a go-forward or prospective basis, to revoke an existing election that might have been made and maybe enroll in a different plan option the employer offers, or to completely revoke the election that had been made as long as that employee is saying that they will or have already enrolled in some other coverage that that employer is not sponsoring. So this can be something that the employer is allowing, but if they do it, they must amend their plan to make sure that this is accounted for. So this is something that, like I said, is optional, but if you do it, there needs to be a modification. The other important caveat to note about this particular IRS notice when it comes to high deductible health plans and the telehealth benefits. So this clarifies within the notice that these services, the telehealth services specifically, are allowed to be provided beyond 1/1/2020, and this can be something that is still not going to sacrifice our high deductible health plan status by allowing these things to be covered without actually satisfying that minimum deductible. So this is welcome news for us. It's giving us the opportunity to make these changes, but should you make any of these changes, please make sure that you're making an amendment to the actual cafeteria plan so you're not running into any issues with the stop loss carriers. And I'll turn it back over to you, Ron.
Thanks. So, simply put, if I was a Supreme Court justice, I would be offended. That's all I got to say. Because years ago, I specifically said that the individual mandate was not a mandate at all, but rather a choice, because you could choose to pay the tax or get coverage. And then, that was the ground, that was the rug I was standing on. Congress pulls the rug out from under me and gets rid of that choice, that tax. And they take an issue that I had thought I very wisely and with great clever strategy was able to get around and put it right back in front of me. So I would be offended that, nobody was paying attention. But apparently, the ACA, it's going to be in front of the court again. The only thing you have to remember is this. Because there was no severability clause in the ACA, if one part of the law is unconstitutional, is the entire law unconstitutional? So that's why it's so important that even if one little bit like the mandate is deemed to be unconstitutional, that could potentially take down the entire law. So this is something we're going to have to keep track of. Again, the ACA before the court. Do I think that this is what will eventually take it down? If I were a betting man, I'd say no, but it's certainly not unfeasible as well, or not feasible. So we're going to keep an eye on this. Obviously, we'll keep you updated, but again, it's important to know that this continues and that the prior decision regarding the constitutionality of the mandate is really, the teeth got pulled out of that decision because they got rid of the tax. Next slide.
All right, in keeping with the Supreme Court here, there's a lot of news that's come out from the court this month because they really rushed to release a bunch of cases. But many of those cases had a lot of impact in healthcare, and this is one of them. This is a long-awaited ruling on the contraceptive mandate case. Again, we've covered this extensively because there's been a number of rulings that have come out from the Trump administration that have narrowed the scope of the contraceptive mandate in the ACA and expanded the number of exemptions available to you as an employer. And this case here, Little Sisters of the Poor versus Pennsylvania, they always have a very sympathetic plaintiff in these cases. In this case, you have one as well. And the court ruled 7-2, which is a big deal because it means it included some of the liberal justices here that upheld the administration's two rules actually, that really expanded the scope for which employers could opt out of providing birth control coverage. Now you can object based on both a religious or a moral objection to providing birth control. It's a very pretty decisive ruling here, written by Justice Clarence Thomas. And effectively what this means, despite the fact there's still some unanswered questions, but employers can now simply decline to cover birth control for employees or students, and they don't have to make the accommodations process available. So the TPA is off the hook as well. If you have an objection, you just certify that you have an objection. Again, this is a little bit unclear about, if you have a moral objection, do you have to write an essay? How do you actually prove that? But it seems like it's pretty final in the sense if you have an objection, you don't have to provide the coverage. And for employers that want to avail themselves of that, they can do that. Let's go to the next slide, which has a similar issue here with some unanswered questions as well. And we covered this a little bit last time, but a little bit more in depth here in the Bostock case, which is about employment law, really, but does have some impact here on Section 1557. So briefly, just in a minute here, remember we have HHS giving their final rule, which repealed the definition of discrimination on the basis of sex, which effectively made Section 1557 inapplicable to most self-funded and fully insured plans. But this ruling from Supreme Court really changes the definition of on the basis of sex, and it really calls into question what HHS did in its final rule. So the removal of gender identity protections from 1557 will bring new lawsuits against this final rule because the rule has effectively included gender identity as a protected class in this case. So what should you do as an employer? First, make sure that you're even in the realm of coverage for Section 1557. Does it apply to you? See if your plan language is in compliance. And just weigh the pros and cons here. If you want to remove benefits or add benefits, our take is that you are probably likely to face lawsuits, or there will be lawsuits on this issue because of how the Supreme Court ruled. For now, I would wait because HHS could modify their rule based on this ruling. We're just not sure exactly what they'll do. But it's a big deal. It's a big case in employment law, and it does really call into question what HHS has done by revising Section 1557. So I would say status quo is the safest bet for now. Let's go to the next slide. And this one's back to Ron.
Great. All you have to know is this, guys. You got a health system out in California that was accused. It settled, so there was no judgment, but they were accused of going out there, purchasing all of the other health systems in the area, all the facilities, all the providers, and once they own the entire market, they violated or were accused of violating anti-competitive rules, antitrust laws in the area. If you think that this is unique to this one health system, I've got a bridge to sell you because, I'm looking at these cases not as specifically relevant to this one health system, but more indicative of what you're seeing as an industry. So again, when you see a case like this and then sort of the subsequent shock and awe by those involved that this could possibly happen, I hope that you're upset, and I hope that you're shocked that people think this is unique to this one situation. The only thing I can say is this: if you see anti-competitive behavior similar to this amongst other health systems in the area, there's something you can do about it. Somebody blew the whistle on Sutter, and as a result, if nothing else, they were forced to settle. So there are things that we can do as an industry, and this is something we do need to keep our eyes on and not just take for granted. Next slide. Likewise, talking about days in court, we know that the price transparency rule that would require providers to post their pricing where it's transparent and available to consumers and payers, it had its day in court and it won. So this is great, but I do want to make it clear that, at least in my opinion, and I've said it many times before, this is really just a first step in the right direction. Because ultimately what this is going to do is it's going to make everybody aware of something that we already know, which is that these prices are all over the place. They appear to be arbitrary. So once people see this and they realize, wow, these prices are all over the place. There's no rhyme or reason to the pricing. So what? What then? That's our job, to step into that void left by that question and say, so this is what you need to do. Because my concern is going to be, if somebody sees that one facility charges much more than another, are they going to say, is there a reason for it? Is the quality of the higher priced facility better? It's our job to step in before someone can even ask that question and ensure that they understand, no, price doesn't indicate quality, and here are reliable measures of quality that you can use. And I think once we have price and quality transparency together, we can start to get people to go in the right direction and be educated consumers. I know our own plan and many of our clients are already doing this, and it's working out very well. But again, this is a victory for us, but it's one step in the right direction, but there's a ways to go. Next slide. Last but not least, speaking of transparency and sort of that question, so what? You had heard previously, I know we talked about it in previous webinars, the idea that there was this rule or proposed rule where drug manufacturers were going to have to post their price on advertisements. That got struck down. Apparently, it exceeded the authority and you need Congress to actually pass a law. That being said, I question how big a loss this is for us, because if people see prices on TV, they're going to ask, so what? Right? The question of skin in the game, am I the one paying, or is this, really only relevant to my insurance? I mean, realistically, how many of your plan participants do you think actually go through their EOB with a fine-tooth comb and actually look at the prices and care how much these things cost? Or do you think they just skip to the end where it says you may owe? So one, I question how useful that information would be. Two, if you know drug manufacturers like I do, they're smart. They would have figured out a way around it. Maybe the drug price would be really, really low, and then there's some sort of a high delivery fee or something like that. I don't know. But the point is, I'm sure they'd figure a way around it. Ultimately, the responsibility, it's not on the consumer. We can't put all the responsibility on the plan participant, on the patient, to do some educated shopping and understand these things just because we think it's commonsensical. You need to take active steps to control costs yourself. And one place where you can do that, as far as it relates to drugs, are the PBMs, are the PBM contracts, analyzing the behavior, questioning abusive tactics, and ensuring that by the time the drug is actually purchased, the price that's posted on the television commercial is really irrelevant. What matters is ultimately the cost that's being paid at the end of the day. And that's where you'll see the most bang for your buck, is with these PBM arrangements. And again, this is an area where we can assist. So with that, I'm all set. I'm going to pass it back to the man, the myth, the legend, Brady Bizzarro. Speaking of costly drugs, Brady, oh boy.
Yeah, just one last thing here on remdesivir. It's in the news all the time now. A lot of people are asking us, employers want to know how much it's going to cost because they're considering covering it as a way to help their employees get back to work, because it actually has a good effect for people affected with COVID-19. The cost for private plans, $3,120 for 5 days of treatment. That's controversial because a lot of taxpayer money went into funding the development of this drug. So a lot of people are up in arms about the cost, saying that it should be a lot less because taxpayer money was involved in developing it. But that's the cost, $390 per vial for the government, $520 per vial for private insurance. So if you want to cover it, that's where it'll cost, and now you know what the cost will be. And with that, I'll turn it back over to Adam.
Well, folks, that's all the time we have for today. Just want to say thank you to all of you for dialing in. Again, we're always humbled by the fact that so many of you in the middle of July decide to spend an hour with us. So please join us for our next free webinar, August 18th, 1 o'clock. You know where to sign up. You know what it's going to be about. We don't know yet. We're hoping it'll be less and less about COVID every single time. We'll try to keep the news upbeat, and we'll share the best information we possibly can. On behalf of Matt Payton, who set this all up, Jen McCormick, Brady Bizzarro, Ron Peck, and myself, thank you so much for joining the Phia Group. Have a great day, have a great week, and see you next month. Thank you.